The Chief Justice of the Supreme Court challenges a Hollywood superstar, expecting to expose his legal ignorance. What happens next will not only shock the courtroom, but could change the way we view justice forever. Stay tuned to find out how Denzel Washington's hidden legal genius turned the tables on one of the highest authorities in the land. But before we dive into this story, I want to hear from you. Comment down below, where in the world are you watching from? Let's light up this comment section. And hey, if you love stories with high drama, power shifts, and the kind of moments that leave people speechless, you're in the right place. Tap that subscribe button right now. Hit the notification bell so you never miss when we drop the next chapter in these powerful, untold stories. Denzel Washington stood perfectly composed at the lectern in Courtroom 3 of the Supreme Court, his tailored navy suit a stark contrast against the imposing marble columns behind him. Just moments earlier, Chief Justice John Roberts had interrupted his oral argument with an unprecedented challenge. Mr. Washington, I find it difficult to believe that someone from your background fully understands the constitutional implications of your position. The statement sent shockwaves through the packed courtroom. Law clerks exchanged glances, veteran attorneys straightened in their seats, and journalists frantically scribbled notes. But Washington, the award-winning actor who had spent the last 5 years secretly earning his law degree while filming blockbusters, didn't flinch as the 9 justices and hundreds of spectators watched intently. Chief Justice Roberts, with his Harvard pedigree and 16 years leading the nation's highest court, was certain he could expose this celebrity's legal inadequacies. He likely expected Washington to be an actor with only a shallow understanding of the law, someone who had come in with little legal training or experience. However, Washington, armed with a constitutional theory he had developed during his studies and a comprehensive knowledge of case law that would shock the court, was about to transform this condescending ambush into one of the most memorable oral arguments in decades. This wasn't just another Supreme Court hearing. It was Washington's moment to prove that brilliant legal minds can emerge from unexpected places and potentially change American constitutional interpretation forever. The tension inside the Supreme Court had been building ever since Denzel Washington's name appeared on the docket for the case, Henderson versus the Department of Justice, 3 months earlier. When the renowned actor had filed an amicus brief, few in the legal community realized the depth of his involvement. Many assumed his role was simply a PR move, just a famous celebrity lending their name to a cause. But the few legal minds who had actually read Washington's 40-page brief began to realize they were dealing with a legal powerhouse. His brief contained a novel legal argument about the original understanding of the Fifth Amendment's takings clause, which challenged decades of precedent. Washington's argument was not merely about civil rights or a popular cause, it was grounded in deep legal scholarship. The brief pointed out that civil forfeiture laws, which allow the government to seize property without criminal convictions, were inconsistent with the original intentions of the Founding Fathers. "I can't believe they're letting him speak just because he's famous," whispered a corporate attorney to his colleague in the gallery. "This isn't Hollywood. You can't just memorize lines and expect to convince the Supreme Court." The stakes were enormous. The case involved the government's seizure of a community center and surrounding properties in a predominantly black neighborhood in Philadelphia, based on a single drug transaction that had occurred on the sidewalk outside. The government hadn't charged any of the property owners with crimes, but had seized millions of dollars worth of real estate under civil forfeiture laws. If Washington's argument prevailed, it could dramatically limit the government's power to seize property without criminal convictions. If he failed, not only would the seizure stand, but his legal theories, developed during years of determined study, would be dismissed as the amateur musings of a celebrity dilettante. The courtroom fell silent as Washington approached the podium. Unlike many first-time advocates who appeared nervous before the court, Washington moved with the quiet confidence of someone accustomed to high-pressure performances. He had spent years preparing for this moment, not just by studying law, but by mastering the art of delivering a compelling argument. Still, few in the room, perhaps none, anticipated how thoroughly prepared he actually was. "Mr. Chief Justice, and may it please the court," Washington began, his resonant voice filling the chamber without the need for amplification. The Fifth Amendment's provision that private property shall not be taken for public use without just compensation was understood by the founders to require not merely monetary compensation, but also a genuine public purpose and basic procedural protections before the awesome power of government could be deployed against a citizen's property. His opening statement was eloquent but unremarkable on the surface. Chief Justice Roberts, who had been reviewing Washington's brief with skepticism, saw an opportunity to expose what he perceived as a superficial understanding. While justices typically allowed attorneys to develop their arguments before questioning, Roberts broke protocol, interrupting just 40 seconds into Washington's presentation. "Mr. Washington," Roberts began, his tone carrying a hint of condescension, "while I appreciate your interest in this case, I find it difficult to believe that someone from your background fully understands the constitutional implications of your position. Your brief seems to overlook 2 centuries of settled doctrine on civil forfeiture." A murmur ran through the courtroom at the unusually personal nature of the challenge. Justice Sonia Sotomayor shifted uncomfortably in her seat, and Justice Elena Kagan frowned slightly. Washington paused, meeting Roberts' gaze directly. Those who knew him recognized the calm that always preceded his most powerful performances. "Chief Justice Roberts," he replied evenly, "I believe my argument is consistent with the historical understanding of the Fifth Amendment as articulated by Justice Thomas in his concurrence in Timms v. Indiana. But perhaps we should examine the textual and historical evidence together." He opened a well-worn copy of the Constitution, along with several original sources that he, unlike most advocates, had brought to the podium. Something in his methodical preparation caught Roberts off guard. This wasn't the surface-level celebrity advocacy he had anticipated. Chief Justice Roberts, realizing his initial dismissal had failed to rattle Washington, leaned forward with a more substantive challenge. "Mr. Washington, your brief argues that the original understanding of civil forfeiture was limited to admiralty and customs cases where jurisdiction over property owners couldn't be established. But you've overlooked the 1827 case of the Palmyra, where this court clearly established broader government forfeiture powers." The question was a trap, one that had ensnared many experienced attorneys in the past. The Palmyra was indeed a landmark case on forfeiture, but its nuances were often mischaracterized. The case involved the seizure of a ship suspected of piracy, and its implications for civil forfeiture in modern cases had been hotly debated. Washington knew this, and he was ready. Without hesitation, Washington responded, "With respect, Chief Justice, I have not overlooked the Palmyra. In fact, on page 23 of my brief, I addressed Justice Story's opinion in detail." He flipped precisely to the page without looking. While the Palmyra did permit forfeiture without criminal conviction, it was fundamentally a maritime case involving piracy, where, as Justice Story noted, the vessel which commits the aggression is treated as the offender. This fiction made sense in admiralty cases where personal jurisdiction was often impossible to obtain. Washington's voice grew more confident with every word. He continued, "But Justice Story never suggested this exception should become the rule for domestic civil forfeiture against American citizens who are fully subject to the court's jurisdiction." The entire courtroom was now listening intently as Washington laid out his argument. He was not just challenging a past decision, he was reinterpreting it in light of historical context, which few attorneys had the skill or courage to do. "In fact," Washington continued, "I've traced every civil forfeiture case decided by this court between 1789 and 1850. All 27 of them. Every single one involved either maritime seizures, customs violations, or piracy. Not one approved the type of land-based seizure from innocent owners that we see in Henderson." The courtroom fell silent. Washington wasn't just familiar with the Palmyra. He had conducted a comprehensive historical analysis that few scholars, let alone practicing attorneys, had ever attempted. This wasn't just a superficial review of cases. It was a deep dive into the foundations of civil forfeiture law. and Washington was proving he knew it inside and out. Justice Samuel Alito, who was often sympathetic to law enforcement powers, jumped in. "That's an interesting historical observation, Mr. Washington. But how do you account for our more recent precedents? In Bennis v. Michigan, this court upheld the forfeiture of a vehicle from an innocent owner." Washington, without missing a beat, responded, "Justice Alito, I believe Bennis was wrongly decided," drawing gasps from the gallery. Directly challenging Supreme Court precedent was a bold move, and Washington knew exactly how to handle it. "And I'm not alone in that assessment," he added. Justice Thomas, joined by Justice Ginsburg, despite their different judicial philosophies, dissented forcefully in Bennis. More importantly, Bennis created a tension in our jurisprudence that this case allows the court to resolve. Washington turned a page in his notes, signaling that he was just getting started. Since Bennis, this court decided Austin v. United States, holding that civil forfeiture is subject to the excessive fines clause, and Timms v. Indiana, incorporating that protection against the states. These cases recognize that civil forfeiture is quasi-criminal in nature and must respect constitutional limitations. The dynamic in the courtroom was shifting perceptibly. Justices who had initially appeared skeptical were now engaged, several taking detailed notes. Court observers noted that Justice Clarence Thomas, who rarely speaks during oral arguments, was paying unusually close attention. Justice Brett Kavanaugh entered the fray. "Your historical argument is compelling, Mr. Washington, but there's a practical concern. Civil forfeiture has become an important tool for law enforcement. Are you suggesting we should completely eliminate it?" "Not at all, Justice Kavanaugh," Washington replied, his calm demeanor reassuring the court. "I'm suggesting the court should restore civil forfeiture to its historical boundaries. It remains perfectly appropriate in its traditional contexts, admiralty, customs, and cases where jurisdiction over the property owner cannot be established. But when the government can bring criminal charges against a property owner and chooses not to, yet still seeks to take their property, both due process and the takings clause impose higher burdens." Chief Justice Roberts, clearly surprised by Washington's command of the subject, attempted a different approach. "Your brief cites several obscure founding-era cases from state courts that most scholars haven't discussed. How can we be confident these represent the mainstream understanding rather than outlier positions?" It was the kind of question designed to expose superficial research. Roberts suspected Washington might have cherry-picked convenient cases without providing broader context. But Washington was prepared. Washington smiled slightly, recognizing the opening. "I'm glad you asked about those cases, Chief Justice," he said, his tone warm but firm. "Far from being outliers, they represent a consistent pattern across multiple jurisdictions." From memory, he proceeded to outline the facts and holdings of 8 state Supreme Court cases from the early Republic, explaining how they collectively demonstrated a narrow understanding of legitimate property seizures. Justice Elena Kagan, visibly impressed, interjected, "Mr. Washington, your historical research is remarkable. Did you work with a team of legal historians to prepare this argument?" For the first time, Washington showed a hint of personal pride. "No, Justice Kagan," he said. "While I certainly read the leading scholars, the primary research tracing these cases through the archives, examining the original documents, I conducted myself during my law school studies at Howard and in the years since graduation." A buzz ran through the courtroom. Many there were learning for the first time that Washington's legal credentials were genuine. This wasn't some unqualified celebrity trying to impress with surface-level arguments. Washington had truly mastered the law, and now everyone in the room was realizing it. Chief Justice Roberts, whose earlier dismissiveness now seemed inappropriate, shifted uncomfortably in his seat as he realized that his attempt to challenge Washington had not only failed, but had given the actor-turned-lawyer a platform to demonstrate his deep understanding of the law. Washington's calm and confident responses had left Roberts with no choice but to reevaluate his approach. Justice Sotomayor seized the opening. "Mr. Washington, returning to the case at hand, how would your historical framework apply to the community center seized in Henderson?" Washington turned directly to address her. The atmosphere in the courtroom had shifted dramatically, with justices now taking his arguments seriously. "Washington, never flustered, took a moment before delivering his response with clarity and precision. "Justice Sotomayor," Washington began, "under the original understanding I've outlined, the seizure in Henderson fails constitutional scrutiny on multiple grounds." He paused for emphasis, then continued. "First, a single drug transaction by a third party on a public sidewalk creates at most a tenuous connection to the property." The room was silent, each word carrying weight. Washington wasn't just attacking the application of the law in this case. He was fundamentally challenging the very principles on which such seizures were based. Second, the government has made no attempt to prove the owners had knowledge of illegal activity. Washington added, "The owners were not charged with any crime. So, how can the government seize their property without criminal conviction, without proof of their involvement? This goes against the basic principles of due process." Washington's voice grew more resolute. "Third, the taking is grossly disproportionate to any harm caused. The government is seizing millions of dollars in real estate, all because of a single, isolated incident involving a drug transaction that didn't even involve the property owners." At this point, Washington delivered his most powerful and provocative argument. Perhaps most fundamentally, this seizure violates the public use requirement of the Fifth Amendment. Civil forfeiture that transfers property to general government funds rather than remedying a specific harm cannot satisfy the public use test as the founders understood it. The impact of Washington's words was immediate. The courtroom, which had earlier been filled with skepticism about his qualifications, was now tense with the weight of his argument. This wasn't just an impassioned plea. This was a deeply researched, logical, and constitutional argument that left no room for easy dismissal. As Washington's argument gained momentum, court officers discreetly extended his allotted time, a rare courtesy that signaled the justice's engagement with his points. In a setting where even the smallest deviation from protocol could be seen as a sign of respect, this gesture spoke volumes. Chief Justice Roberts, now fully attentive, recognized that far from embarrassing Washington, he had inadvertently given him the perfect platform to demonstrate extraordinary legal acumen. The stakes had escalated far beyond the initial confrontation. What had begun as an attempt to humble a celebrity had transformed into a serious reconsideration of constitutional doctrine. What followed was a palpable shift in the atmosphere of the Supreme Court. The justices, who had once been skeptical of Washington's involvement, were now captivated by his command of the legal and constitutional arguments. Washington had taken control of the conversation, presenting his case with such authority and depth that even the most experienced jurists could not help but listen intently. As the tension mounted, Roberts, clearly recognizing that Washington had exceeded expectations, sought to recover some professional ground. He attempted one last question, this time focusing on the practical implications of Washington's argument. "Mr. Washington," Roberts asked, "your historical analysis is certainly thorough, but I'm still troubled by practical implications. If we accept your framework, numerous existing forfeitures might be called into question. Have you considered the reliance interests at stake?" It was a legitimate concern. The court often weighs the practical implications of a ruling, considering how a decision might affect established legal frameworks and the reliance of various stakeholders on those frameworks. Washington, however, was ready for this line of questioning, knowing full well that he had anticipated this very concern. "Chief Justice Roberts," Washington replied, pulling out a document that appeared to contain detailed statistics, "I have indeed considered the practical implications carefully." He laid the document on the podium, and his voice was calm but filled with conviction. "I've analyzed data from the Department of Justice's asset forfeiture program over the past decade. Approximately 87% of current forfeitures would remain untouched under my proposed framework, those involving unclaimed property, customs violations, and cases with criminal convictions." Washington paused, giving the justices time to process the data. He then continued, "The only forfeitures that would be affected are precisely those that most offend our constitutional traditions, seizures from innocent owners based on tenuous connections to alleged wrongdoing, often without any criminal charges filed." He looked up from his notes, his gaze steady. These represent less than 13% of forfeitures by value, but they cause disproportionate harm to communities like the one in Philadelphia, affected by this case. The justices appeared to take note of Washington's careful consideration of the practical consequences of his argument. The court was no longer just listening to a celebrity advocate. They were engaging with a legal scholar who had carefully thought through the broader implications of his position. The complexity of the issues and the potential far-reaching effects of his proposed framework was not lost on them. Justice Amy Coney Barrett, who had been listening intently throughout, spoke up. "Mr. Washington, your brief makes an interesting textual argument about the relationship between the Due Process Clause and the Takings Clause that I don't believe any scholar has previously developed. Could you elaborate on that?" The question was a sign of genuine intellectual curiosity. Washington's argument had clearly caught the attention of the court, and now they were eager to explore it further. "Justice Barrett, thank you for that question," Washington replied, his tone respectful but confident. "While these clauses are typically analyzed separately, the historical evidence suggests the founders understood property protections holistically. When government action deprives citizens of property without meaningful procedural protections, it implicates both clauses." Washington's eyes gleamed with intellectual excitement as he continued. James Madison, who drafted both protections, wrote extensively about the interconnection between procedural fairness and substantive property rights. In a letter to Jefferson in 1788, he explicitly connected arbitrary seizures to both due process violations and uncompensated takings. At this moment, Washington reached into his folder and removed a photocopy of a handwritten letter. "I took the liberty of visiting the Madison papers at the Library of Congress while preparing for this argument. This letter hasn't been cited in previous forfeiture cases, but Madison clearly states that the seizure of a citizen's lands without proper process or public purpose constitutes a double violence against the right most sacred in ordered society." Justice Thomas, who had remained silent but deeply engaged in the argument, finally spoke. His rare interjection startled the courtroom. "Mr. Washington," Justice Thomas said, "your originalist approach is refreshing. You've persuasively shown that civil forfeiture as currently practiced extends far beyond its historical boundaries. But I'm curious, how would you distinguish this case from Bennis? Would you have us overturn that precedent explicitly?" The question went to the heart of the court's stare decisis doctrine, which emphasizes the importance of adhering to established precedents. Washington's response would need to balance a respect for the court's previous decisions with his argument for a new approach. Washington responded with precision. "Justice Thomas, while I believe Bennis was incorrectly decided, this court need not explicitly overturn it to rule for the petitioners in Henderson. Bennis involved a vehicle used directly in criminal activity, maintaining at least some connection to the historical understanding of forfeiture. Henderson involves real property with only the most attenuated connection to any crime. The court could distinguish these cases while clarifying that civil forfeiture is constrained by both historical practice and constitutional limitations." This nuanced response, respecting both the court's respect for precedent and Washington's argument for a more limited understanding of civil forfeiture, demonstrated his sophisticated understanding of how the court operated. He wasn't merely making abstract legal arguments. He was providing the justices with a doctrinally sound path forward. Washington, now clearly in command of the conversation, responded to Justice Kagan's question with characteristic confidence. "No, Justice Kagan," Washington began. "While I certainly read the leading scholars, the primary research tracing these cases through the archives, examining the original documents, I conducted myself during my law school studies at Howard and in the years since graduation." The courtroom buzzed with the revelation that Washington's legal education wasn't just a personal interest. It was a rigorous, deeply engaged pursuit. His ability to conduct historical legal research on his own, without relying on outside experts, demonstrated not only his passion but also his intellectual independence. Chief Justice Roberts, who had initially been skeptical of Washington's qualifications, shifted in his seat, clearly recognizing the depth of Washington's legal understanding. He had underestimated Washington's preparation, and now the justices were seeing a new side of the actor they had once dismissed. Justice Sotomayor pressed further, asking Washington how his historical framework applied specifically to the Henderson case at hand. Washington was poised, taking his time before delivering a carefully structured answer. "Justice Sotomayor," he said, "the seizure in Henderson fails constitutional scrutiny on several grounds." He laid out his points systematically, starting with the tenuous connection to the property and moving to the lack of criminal charges against the owners. Washington didn't just argue against the seizure, he reframed the issue in constitutional terms, arguing that it violated the Fifth Amendment's protections against the taking of private property without just compensation or public use. As he spoke, his arguments gained momentum, and the justices who had been skeptical of him earlier were now visibly engaged. The power of Washington's analysis was inescapable, leaving no room for doubt about his legal expertise. The aftermath of Washington's oral argument spread quickly, with legal circles buzzing about the unprecedented moment they had just witnessed. Law professors immediately assigned the transcript to their students, and constitutional scholars from all ideologies weighed in, many expressing surprise at Washington's depth of knowledge. Legal analyst Jeffrey Toobin, who had covered the Supreme Court for over 2 decades, remarked, "Denzel Washington didn't just hold his own against the Chief Justice, he delivered one of the most compelling originalist arguments against civil forfeiture ever presented to the court." Social media quickly picked up on the moment, with hashtags legal scholar Denzel and Denzel teaches the chief trending. Clips of Washington quoting historical documents and reciting case law spread widely, reaching millions. A new side of Washington, the legal scholar, emerged, captivating not just his fans but also the legal community. The following morning, the New York Times revealed details of Washington's legal education at Howard University School of Law, where he had earned his JD with honors while keeping it private. Professors praised his dedication, noting his passion for constitutional history and civil rights, and how he never sought special treatment. Legal blogs and podcasts dissected every aspect of the argument, highlighting Roberts' shift from dismissive to respectful as the case progressed. Washington's argument, once perceived as celebrity activism, was now seen as a serious and well-researched legal position. 6 weeks after Washington's compelling oral argument, the Supreme Court issued its decision in Henderson v. Department of Justice. In a surprising 7-2 ruling, the court sided with the petitioners, significantly limiting the government's civil forfeiture powers. Chief Justice Roberts assigned himself to write the majority opinion, a move many saw as a gracious acknowledgement of his earlier misjudgment. In the opinion, Roberts noted, "After careful consideration of the historical record and constitutional text, we conclude that civil forfeiture, as currently practiced, has expanded far beyond its original boundaries. While civil forfeiture remains a valid tool in appropriate contexts, the Constitution does not permit the government to seize private property from innocent owners based on tenuous connections to alleged wrongdoing, particularly where, as here, the property serves important community functions." What was most remarkable was that the opinion directly quoted Washington's arguments multiple times, including his 3-part test for evaluating civil forfeitures. The court credited Washington's research for providing a clear historical framework that helped shape their decision. Justice Thomas wrote a concurring opinion, calling for a full re-examination of civil forfeiture doctrine in light of the original understanding. Justice Sotomayor, meanwhile, emphasized the disproportionate impact of forfeiture on disadvantaged communities, citing statistics Washington had provided during the argument. In a final personal touch, Roberts added in the opinion's last paragraph, "This case reminds us that legal wisdom can come from unexpected sources, and that our system of justice is strengthened when diverse voices and perspectives are fully heard." This statement was widely interpreted as an acknowledgement of Washington's contribution. The decision led to immediate changes. Several states reformed their civil forfeiture laws to comply with the new constitutional framework. Innocent owners who had lost property in forfeiture cases saw their assets returned, and law enforcement agencies began to focus on forfeitures tied directly to criminal convictions, rather than the more tenuous claims that had become the norm. For Washington, the case marked a new chapter in his career. While continuing his acting work, he established the Washington Justice Initiative, a nonprofit aimed at providing legal assistance to communities affected by civil forfeiture. Leading law schools invited him to give guest lectures on constitutional history, and 6 months after the decision, he and Chief Justice Roberts appeared together at a forum on civic education. Their discussion, marked by mutual respect and humor, demonstrated the power of legal discourse to bridge divides and generate real understanding. Roberts publicly acknowledged that Washington's argument in Henderson would be studied by law students for generations. The Henderson case had profound implications for the legal community and society at large. Washington's argument not only reshaped the court's view on civil forfeiture, but also challenged the traditional boundaries of the legal profession. The decision inspired a wave of reform, with several states swiftly revising their civil forfeiture laws to align with the court's new constitutional framework. Millions of dollars worth of property was returned to innocent owners, particularly in disadvantaged communities where the harm caused by aggressive forfeiture practices had been most acutely felt. The ruling also had a cultural impact. Washington's standing as an advocate for justice expanded beyond his celebrity persona. While he continued his acting career, Washington became a symbol of how non-traditional paths to legal knowledge could lead to meaningful change. His new nonprofit, the Washington Justice Initiative, worked to provide legal assistance to communities affected by civil forfeiture, further solidifying his role as a serious legal advocate. Legal scholars and students were quick to embrace Washington's contributions. His arguments became a touchstone for constitutional law discussions, with law schools across the country incorporating his approach into their curricula. The court's final opinion, which cited Washington's work several times, reinforced the idea that legal wisdom can come from diverse sources, not just traditional legal elites. 6 months after the decision, a historic moment occurred when Washington and Chief Justice Roberts appeared together at a forum on civic education at Georgetown Law School. The event, marked by mutual respect and the lighthearted acknowledgement of their courtroom encounter, showcased how adversarial legal proceedings could lead to growth and understanding when conducted with integrity. Roberts, once skeptical of Washington, publicly acknowledged that the actor had taught him a valuable lesson. "Mr. Washington taught me a valuable lesson that day," Roberts said. "Never confuse celebrity with capability." Washington, with his characteristic humility, responded, "The beauty of our legal system, when it functions as intended, is that arguments stand or fall on their merits, not on the identity of those who make them." The event became a symbol of overcoming preconceptions in the legal profession, reinforcing the idea that preparation and knowledge, not one's background, should define their place in important legal discourse. As Washington reflected on the experience, it was clear that the case was not just a personal triumph, but a lesson for the legal system and society. Justice, fairness, and legal wisdom can come from anyone, no matter their background. The story of how a Hollywood icon humbled the Chief Justice, not through celebrity but through scholarly excellence, resonated far beyond the courtroom. It became a modern parable about judgment, opportunity, and the ongoing American struggle to create a legal system where ideas truly matter more than identity. Denzel Washington's unexpected journey from Hollywood to the Supreme Court is a powerful reminder that brilliance can come from anywhere. His ability to challenge long-standing legal precedents and reshape the conversation about civil forfeiture proves that preparation, determination, and a commitment to justice can make all the difference. His story not only inspired legal scholars and reformers, but also demonstrated the importance of overcoming assumptions and valuing ideas over identities. If you found this story as inspiring as we did, be sure to like, subscribe, and leave a comment below. Let us know your thoughts on how preconceived notions can limit our recognition of brilliance. And remember, the law and life always rewards thorough preparation and the courage to stand up for what's right. Thanks for watching, and we'll see you next time for more incredible stories of justice, perseverance, and unexpected excellence. See you in the next video.